تسجيل يا جماعه، الجماعه ربنا يكرمهم الادمنز، تقدروا تبتدوا التسجيل. واضح ان التسجيل اصلا ابتدى. طيب welcome to the second session of this series. I'm saying series because I'm going to do it as a series. I'm not going to stop at lecture number 2. I'm going to move on for those who are interested in the subject of not only delay analysis, but subjects related to project management. So I'm going to conduct a series of sessions based on availability and the time allowed for recording whatever experience I've been through my career, which is now spans over 22 years and 9 countries. It's not it's not a matter of pride. It's just a matter of bewilderment because time flies. I remember that it's not a personal comment, but it's just a more professional comment that I remember that I've been graduated as if it was yesterday. So starting my career, looking for the discipline I'm going to follow, and changing to project management, or shifting to project management, and starting after 7 years of graduation, and then all of the sudden I went in a short trip, and all of the sudden I found out that I'm 45 years old and with 22 years of experience. So I think I've been through a lot of challenges, failures, success, and what I've been through worth being transferred as lessons learned, what to do or what not to do for those who are interested, of course. So I'm going to continue recording these and conducting these sessions in live mode or in a recording mode. And actually, the content of the 2 sessions will not end here because as I was explaining to the organizers, thank you very much again for your efforts. I was explaining to the organizers this morning that I was rehearsing last week for this session, and I found out if I go for the extension of time tricky examples, it would take 8 hours or 9 hours to complete the session. So I decided to go for the apportionment loss or expenses method of calculation today. And I've already started yesterday separating the examples and recording the examples in separate sessions that will be supplied in the group during the coming period. The first one is ready, and with the organizers, I think they will upload it as soon as possible, and the rest will continue going on during the coming period. So today we will go through again. Today we'll go through the first 2 items of the content, and the third item will be supplied to you in a series of videos starting maybe tomorrow or after tomorrow, and then it will go on for the 5 examples. I have 5 examples: 1 3.3, 1 3.4, 1 3.7, 1 2 3.7, 1 prospective analysis. So this is just watch the first video that will be the first 2 videos actually that will be supplied to you within today or tomorrow or next. I don't think it will take next week because they are already with the organizers. So just take a look at these 2 videos. They are mostly a half an hour in total, not individually, not each half an hour. It's the 2 of them are half an hour. Have a look as a start, as a common ground for whatever we are going to explain in the upcoming remaining part of this series. And the upcoming is going to be only the examples. Anyways, today we have 2 items, very important items actually, related to what we started last session. First item is the apportionment concept in details, and the other one is the famous method that are widely implemented for calculating the apportionment between two parties going into a dispute. Again, concurrency is part of the apportionment. That's what brought the apportionment as part of what delay analyst, with all the conservativity on the word delay analyst or the job title delay analyst, I do have as an individual. This is my view, not your view. This is not a common view. This is my view. My view again is that it's very limiting to do your job or be in a position of something like delay analyst, because your job will be linked to disputes, and the job will be linked to something that is not supposed to happen actually. But anyways, the surprise is that delay is always happening. Delays are always happening. So I think it's a part of other positions job, like project controls or planning manager or planning engineer or senior planning engineer. But anyways, this is not the right context to discuss this issue. But anyways, that's what brought apportionment as part of what the delay analyst cannot be aware of, as the correlation between apportionment in part and concurrency in part. And as I mentioned last in the first session, that one of our esteemed teachers, Dr. Firas Hamdan, I shared the cover page of his book, his Arabic book about delay analysis in the group. And I'm sorry I didn't share the PDF. Just for copyright issue, I'm a bit conservative about sharing documents that I don't have the permission of the author to share. But anyways, it's available. I think if you Google it, you will be able to do it to get it. But my point is that Dr. Firas indicated some methods of calculating the concurrency, and what I found out in further researches that these are originally apportionment methods that we are going to see today. And it has been they have been used as a supporting method to calculate the concurrency. However, they are originally apportionment method of calculation, and all across the way, along the way, we will find out a lot of concepts that are originally apportionment, and we used it in delay analysis. So they cannot be separated, and the delay analyst should understand that he's working in an apportionment mood, and he or she are using the concept of other or a bigger using the concept of a bigger picture called apportionment, and the apportionment is wide open to all types of damages that may the contractor suffer or the owner suffer. Of course, some of you are more experienced than me in the term of contract. So what I'm going to just as a disclaimer, or let's say not a disclaimer, because you are not going to sue me for sure, but as a disclaimer or as an expectation management, I'm going to deliver the concepts in the essence of project controls and delay analysis perspective. So I'm not a contract person. I'm a project controls working in the field of construction, and I'm doing delay analysis I've been doing delay analysis for a while, which exposed me to a lot of contractual concepts. So I'm trying just to make peace between the two parties. Let's move on. Just stop wasting or investing time in general discussion. Again, I'm reminding you of my references. My references are the delay and disruption in construction contracts, the 5th edition by Andrew Boer. And this one is general, the schedule assessment guide, best practice for project schedule, and the Association for Advancement, the two RP. And also, I believe you are opening the camera. I'm using this book also. This is called Construction Schedule Preparation, Liability, and Claims. I didn't have the chance to take a picture of this book, but I'm using also this as one of my references. So let's move on. First, let's just differentiate between two concepts or two terminologies: liquidated damages or delayed damages and penalty. In one of the references, or it indicates, in one of the references, it indicates that there are some mixing or confusion between the concept of damages and the concept of penalty. Some contracts contain clauses that imply a certain amount versus each day on the contractor if he passes the time for completion, if he has not achieved the time for completion. So in terms of penalizing someone, this is, in some court cases, are not accepted. You cannot penalize someone with a limitless amount. You have to be capped. You have to follow a certain procedures to implement damages. So when some contractors could prove that this is under definition is a penalty, they had some kind of escape from implementing the total amount upon them. There are some cases included in the green book I showed that in which the contractor managed to escape or to get relief from the damages, or the part of the damages amount, or part of the amount due to the employer because of his delay to achieve the time for completion, because he somehow proved that this falls, or this amount falls under the definition of penalty, not liquidated damages. So I just created a simple book summarizing whatever inside what was included in the differentiation between damages and penalty, and the differentiation or the comparison is related to enforceability, essence, and definition. The enforceability, the delay damages are enforceable, while the penalty is not. The penalty is not enforceable. And the essence of liquidated damages, and this is very important, is a genuine convented pre-estimate of damages. So it's linked with damages. You have to have some link with a damages that a certain party has suffered due to the delay or due to the offending party, and in order to enforce this kind of damage. The essence of penalty is payment for money stipulated as term of the offending party. It's just a certain amount to penalize someone because he did something, or he delayed, or he mixed something, or he didn't achieve a certain milestone. So it's the penalty in concept is a payment of money stipulated in a term of the offending party. The offending party is the one who did or did the contract breach. The liquidated damages, and by definition, the liquidated damages or the liquidated or certain damages are reasonable pre-estimate. This is very important. It's a pre-estimate of the losses the employer is likely to incur in work if work is completed late. Such a sum is enforceable if, due to his own default, the contractor completes the work late. It's as simple as this. The employer is stating that I'm going to, if you delayed by 1 day, this day will give me or will equal to losses on my shoulder equals to this amount of dollars or sterling pound or whatever. So I will enforce the damages based on a contractual base. And the penalty is a sum of the sum included in the contract, which intended to penalize the contractor and is far greater than the employer's estimated losses. So it's not binded. It's not binded by the employer losses, and such sum would be unenforceable because sometimes it's just, and I've seen this in a lot of development contract, that the owners or the developers is pushing penalties that are far higher than the pre-estimate of losses. So if he's going to be penalized by his client, the owner of the unit, with $1,000, he enforces if $1,000 per day multiplied by, let's say, 200 units. So he's going to be penalized if he delayed the whole building with 200,000 whatever currency. If he's going to be penalized by his clients, by the unit's owner with 200,000 per day, he put a clause in the contract with $350,000 or $500,000 per day if the contractor delays for 1 day. So this is not an estimate of damage. If the owner could prove that this is a good estimate or a reasonable estimate of damage that he's going to enforce, and defines this as a damage, if they went to dispute or court or something like this, or any kind of dispute resolution, the dispute jury or the tribunal or whoever going to give a determination for this one would consider the redefinition of the amount implemented on the contractor, whether it's a damage or penalty. And what differentiates between damage and penalty is the definition here. The sum, the damages are following a pre-estimate amount, evaluating the losses that the employer will suffer due to finishing late. However, the penalty is just a sum to penalize the contractor if he did not finish, and it has nothing or has no ground basis or has no ground calculation that defines this amount or justifies this amount. Again, I'm just reminding you of a general ground rule. There is a group. I prefer to go with the flow, explain whatever included and whatever I have in mind, but feel free to go and ask whatever question you want. I received a lot of questions in the personal WhatsApp or in the group, and I tried my best to answer them also. Please just write down your question. If you have any question all along the way, write down the question and feel free to discuss it with me starting today and upfront. So the other thing is, I'm going, just for the sake of network stability, I'm going to turn off the video and I'm going to open it again at the end of the session. So let's move forward. There are two comments related to the damages. I took these comments from a reference that listed the Green Book also. There was a list with some description of court cases related to the differentiation between damages and penalty. And there are two important. I thought, though, there were many points, but I thought that these 2 points are, or these two important notes are really important. So the first one is the question whether a sum stipulated is a penalty or liquidated damages, which will differentiate between the enforceability and unenforceability. The damage is a question of construction to be decided upon the terms and inherent circumstances of each particular contract, judged of at the time of the making of the contract, not at the time of the breach. So the evaluation, whether it's a pre-estimate or a penalty, should consider the time of making the contract, not the time of the breach. It's instructive, and this is also a historical record, a statistical historical record. It is instructive to note that of the many cases which have come before courts where a liquidated damages sum included in a contract has been challenged as being a penalty, few have been successful, because normally no one wants to destroy the other party, and this is not a good mindset in contracting. On the other hand, most of those who are writing contract are very clever and experienced not to put a gray zone in terms of defining whether this is a liquidated damages or penalty. So when it goes to court, out of the statistical analysis, few of which challenged as a few of which cases that have been challenged to be damage penalties, not liquidated damages. Few, very few, actually I can say very few also have been successful. So this is just in a nutshell the differentiation between two, and let's come back to what the delay analyst cannot be unaware of. What we should know that when we calculate damages for each party, we are not dealing with penalties. We are not penalizing. We are dealing always with damages. And normally there in some cases damage, or actually most of the cases in the cases I experienced in contracting, most of the damages have a ceiling. Most of the damages normally have a ceiling, so I cannot exceed the ceiling in applying liquidated damages. I'm not talking also about liquefaction of the letter of guarantee. This is a totally different procedures and a totally different process and procedures associated with the contract termination. But anyways, we are talking here about the differentiation between the penalty and the damages, and we should highlight that, guys, in extension of time claim, calculation of prolongation cost, or calculation of delay damages, we are dealing with damages. So we are estimating what has been suffered as losses, and we are compensating the losing party on against what he has or what they have lost. So this is what we are doing in delay damage, in delay analysis. Moving to the other subject, which is the name of the game, which is the apportionment. Again, you have seen this in the last one, where I mentioned that the apportionment is the big umbrella of a lot of other things. It's a matter of proportional calculation of the contribution of each party to the losses occurred. In extension of time, it's connected with concurrency. It can be connected also with damages, with bonus, with force majeure, with losses, with unforeseen issues. Unforeseen issues can be escalation, inflation, pandemic. It's not. I separated between unforeseen issues and force majeure. Force majeure is the act of God, or the act of everything is an act of God for those who believes. But anyways, the force majeure is not like the unforeseen issue. Unforeseen issues can be escalation, can be decrease, can be escalation, can be unforeseen condition technically, like the geotechnical unforeseens, stuff like this. Anyways, in order just to move forward with the apportionment, we need just to understand that apportionment is not concurrency. Concurrency is part of the apportionment. I will keep repeating this from here up to the end. Apportionment is sometimes a matter of evaluation. The proportional implementation of damages, or the proportional coverage of damages between two parties or more. Normally, in criminal cases, the standard of proof is beyond reasonable doubt. So if we are in a criminal case, we have to get over or beyond any reasonable doubt to give a judgment as a court or as a tribunal. In the civil cases, what we are dealing with, the standard of proof is based on the balance of probabilities, which is apportionment. We are balancing the probability just to see whether we are going to judge to this party, or give a judgment or a determination in the interest of one party or another, or some kind of apportionment between both. Apportionment of some sort is necessary in many issues of causation. In its simplest form, it is no more than a mental process of rationalization of facts, without which some issues could not be resolved at all. So we have a case, we need just to assess the contribution of damages and the contribution of breach between two parties, and go to the proper determination based on the balance of probability. In one of the methods that we are going to use to calculate the apportionment, which is the dominant case theory, I've just put it here as a quote, and we'll come to this later. It has nothing to do with extension of time. This has nothing to do with extension and liquidated damage. It's just a legal theory relevant to recovery of damage and not relief from damages. It is dealing with damages that have occurred. It's dealing with damages that have occurred. This is apportionment. Let's just stop theoretical talking for a while and give two examples, live examples with projects I've dealt with. First project was in an environment that suffers escalation due to the pandemic or the pandemic the pandemic circumstances that occurred between the 2020 and 2021. The supply chain issues, the escalation issues, the stuff like this. So once we established an understanding that we need our project to be completed in a proper way, we understood, the parties understood that there is a damage due to the price escalation, the inflation, the late delivery of material, and. So this damage is going to be separated on the concrete, the aggregate, the long lead items. We identified the items that is going to suffer or suffered already damages, and we are calculating these damages. It's not a liquidated damages. It's damages due to price escalation and the normal inflation, the interest rate, the financial circumstances that surrounded the consequences of the pandemic. Anyways, two parties, the design builder, which was the contract was design build, and the employer with his consultants, defined list of items, and all of a sudden they found out that most of the items are falling under the inflation and cost escalation. So they went back and said, guys, we both suffered damages. So we need to establish an apportionment agreement or apportionment concept agreement to recover these damages. So we are not going to separate it 100%, or we were going, neither party will hold the 100% impact. But let's say that if the total cost escalation or the price increase exceeded, if the price increase exceeded 15% and the total increase exceeded 100,000, we would sit together and establish an apportionment agreement that the contractor will hold 30% of the damages and the employer will hold 70% of the damages, and we will issue this as a price escalation. We call it here, they called it PCO, potential contract change, potential change order. But we will issue this in something called the ledger. There is a ledger. A ledger is a log of specially defined change orders, and we will put this in something called ledger, and we'll start ledger 1, ledger 2, ledger 3. So we pay it in a timely manner. But the concept is you have to have in the market we have to have a price escalation that exceeds 15%, and we have a total increase in this item exceeds $1,000. Once we have this, we will start implementing the apportionment in a potential change order that puts 30% on the contractor and 70% on the owner, and we will use the actual invoicing records. We are not going to this is your damages. For example, if we are doing the concrete and the concrete is increased by 100,000, 120,000 and 120 increased by, not the original price, increased by 120,000. The 120,000 is more than 15%. It's more than 100,000. So we will divide it 30-70. The contractor will issue a change order for the 70 and will forget about the 30. So this is an example. The other example, there was a case study in my certification for expert determination or expert determiner certificate from the RICS. And one of the issues is a question: which party is responsible for paying the RICS and the legal cost and expert fee and expenses? So this is an issue. One of the there were 12 issues that needs to be determined. The determination was, I looked at the history and I see that the parties share responsibility of a raising dispute. As they elected not to stipulate a clear method of measurement or definition for the fair rates in their collaboration agreement, and also elected to adopt the silent fashion in many controversial points defined as potential dispute subject. So those who developed the contract, this is a determination, which means that they went to a dispute and they elected someone to give a determination for this dispute. So the one who supposed to be me reviewed the history and found out that they shared the responsibility of having this dispute. So they both fall into an apportionment of whatever they suffered. They suffered a damage. They are going to pay for the RICS, they are going to pay for the legal cost, and they are going to pay for me, and they are going to pay for the any expenses related to this subject. So the determination was the RICS and the expert fee to be paid on equal portion contribution of both parties, and parties 2, party 2. This was mentioned clearly in the agreement, but whatever has not been defined in the agreement, they have to pay it 50-50. So the apportionment here was 50-50. This is just to give you an example of that the way or the mindset of apportionment related to damages. So it's always related to damages, and it is separating the damages between two. And I gave you an example last in the previous session about my last project in Egypt before leaving. We elected as the owner because we needed the building as soon as possible to hold or to recover. I'm just trying to choose the right word, to guard or protect the contractor from any potential currency value fluctuation. So we are like amending the contractor or protecting the contractor from that market circumstance. So we put a clause in the contract stipulating that we are going, as the owner, we are going to hold or recover or cover the contractor with 100% of any price fluctuation versus the dollar value at the time of contract signature. There is another example here. Giving a clear or another way of defining apportionment. It's simply saying that as I told you last time, I'm not in this kind of sessions. I'm trying to make. I have a question here, Mr. Alim. Go ahead, please. Open the mic and ask questions, please. You can ask the question. No problem. You can ask the question either in English or Arabic. There is no problem. And go ahead.
Can you please translate apportionment in Arabic phrase, please?
Apportionment means التناسبية أو النسبية أو مش not النسبية التناسب. Apportionment means التناسب.
Yes, I got you.
Okay. So let's go back to the right word of what we have done with the contractor is indemnifying. We have indemnified, but indemnifying is not also the right word, because this is what came to my mind and make me just a bit confused. Indemnify, it means indemnify in terms of legal or legislation, but we protected the contractor from the market condition, the Egyptian market condition at that time, which suffered a great uncertainty related to the dollar prices. And the dollar prices, so we decided to put a clause in our previous project contract to cover the contractor with 100% of whatever change in the dollar value versus the dollar value at the time of the contract signature. Again, I'm coming here to case study number 2. I'm not going to do like Hossam Shawali again and read all whatever in the slide. But what I'm trying to say is that my slides are not just a picture statement. It will include some information. So just so that when you come back to this as a summary reference, you can just understand or take some notes related to whatever we explained. Engineer Nurhan, I can see your hand raised. Please go ahead if you have a question. Okay. The other, I presume that there is.
I'm just saying that I'm.
Excuse me.
Sorry? I believe that getting in the hardship theory and the mechanism of compensating the contractor for damages is some kind of a whole different thing than the.
I'm sorry, الصوت مش واضح خالص. The voice is not clear. الصوت مش واضح باشمهندس.
Is it better now? Is it better now?
Yeah, it is. Go ahead, please.
Okay, I'm just saying that I believe that the hardship theory and exceptional circumstances and the like of theories or legal theories, I believe it's some kind of an area that has a special measures for compensating the contractors or indemnification, exactly. So I believe that this area is kind of special area. I believe it's so special in apportionment. So it doesn't give a full compensation actually for the contractors or for the party that has suffered the damages. So would you please get in more examples that is talking about the normal, that really is concerned with the normal cases or normal exceptional time, because these are so exceptional or so particular cases. This is my humble point of view, and of course it's your call and the others. Thank you.
Yeah, I agree with you 100% that if we dive into a contractual aspect or in the contractual aspect of this one, it would be a bit complicated and but let's say we are going to deviate from the right context that I'm delivering in this session. However, yes, my major concern here is giving examples related to extension of time, because what I've stated as an example are not intended to discuss the contractual procedures. It's just giving the taste of the concept of apportionment. So the previous two examples, the one related to West Davis, the one related to the price escalation, and the other one related to NBK, the National Bank of Kuwait headquarters in Egypt, which we as the owner, we hold the responsibility of indemnification of the contractor related to the 100%. This is just, I'm not intended or not to attempting to explain the contractual basis and discuss the contractual basis. I'm just giving the concept of apportionment. But in this case, the case study we are having here, which I'm going to explain now, is purely something related to extension of time. So in this case, the contractor started working, and he's supposed to develop something called the setting out layout, or the setting out layout, or he did not use the setting out layout for setting out the building, and this resulted in he, for a reason, he didn't have the proper resource to use this drawing. So, but he used an issued for construction drawing coming from, it's a design bid build project. So he issued a normal, or the issued for construction drawing layout for the first floor supplied by the contractor, or supplied by the owner. Unfortunately, he found out that the owner's drawing was in error. The slab reinforcement drawing for the first floor dimension was in error. So this resulted in extra excavation and extra work that gave a delay to the critical path. So the question here in relation to this case, as an apportionment for the purpose of compensation, and the compensation here is due to, not due to the setting itself. The compensation here is against an extension of time. So the contractor is only entitled to recover from employer loss suffered because of the knockout effect of delay the progress because the employer cost risk event. So can this be, and this is just a statement of discussion. Again, the case is there is a delay here, that there is a delay occurred here, okay? There is a delay occurred here, and the delay is due to using another document supplied by the employer. However, there was an issue at the beginning that the contractor didn't use the setting out drawing. So he supposed the normal procedure is the contractor should do the setting out drawing and use it for setting out the building and do the excavation based upon. Unfortunately, he didn't do this for a reason. It's not our concern, the reason now. But he used another drawing which is supposed to be correct, because this drawing is issued for construction by the employer. And this drawing was found to be an error. This problem caused a disruption, not disruption, a disturbance or a disturbance to the critical path and a delay. The question here, and this is for discussion, and actually there is no right wrong answer, because this went to a court and the court decided something. But anyways, who is in fault here? The contractor who didn't use the setting out drawing, or the owner who supplied the drawing that should be correct and can be used to replace the setting out drawing, at least with less damages based upon the contractor? Feel free to open the mic and give your opinion. It's just an open discussion. There is no right wrong answer here. Please feel free to open without even raising your hand. Just open and give a note. Go ahead.
Hello حسام. Hello everyone. طب
Go
انا
ahead.
بس معلش انا هضطر بس اقولها بالعربي.
تفضل.
ممكن اوكي. هو انا بشوف ان هو الكونتراكتور في كل الاحوال لما بيجي له دراونجز هو لازم يتاكد من صحه الامبلمنتيشن او الفيت اوت بتاع الدراونجز دي، لان حتى في العقود دلوقتي اللي كلها موجوده الديفلوبر دايما بيحط المسؤوليه دي على المقاول، لان هو كده هو من شغله ان هو يشوف صحه الرسومات دي او صحه السيتنج اوت او اي مكان هيكون فعلا مناسب وملائم ان هو يشتغل عليه ولا لا. فانا بشوف ان الكونتراكتور هنا بيبقى عليه liability. Thank you.
Okay, thank you. Any other opinion? Again, it's a design bid build project. The contractor should be dealing with the setting out drawing, but he didn't. He used another issue for construction drawing supplied by the owner, which was found on error. This caused an extension of time, and the question here is not whether we have a concurrency or not, but the question here is, are we going to hold the contractor fully liable for this one, or we can do some kind of apportionment between the two parties? The first answer was, which again, there is no right or wrong here. The first answer was, yes, the contractor should be completely liable for what happened. Is there any other contribution from your respectable opinion?
Yes, please.
with you, Abdul.
Yeah, go ahead and feel free to do it in Arabic or English. There is no problem with that. Just go, Mr.
Okay.
Abdul Alim.
Okay, I can speak in
And
Arabic,
then
please.
Mr. Ahmed Al-Fawal, I think he has a contribution too. So we'll take Mr. Abdul Alim and then Mr. Ahmed Al-Fawal. اتفضل.
ثانك يو. اعتقد ان هي مساله هتبقى مساله عقديه او تعاقديه بحته، يعني هنرجع فيها لشروط التعاقد. وحتى
suppose that the contract is silent.
excuse me.
Just to make it افترض ان العقد مش قايل حاجه. silent.
I don't know but يعني اعتقد ان ممكن يبقى فيها راي خبراء. اصل ده الموقف هنا هيبقى موقف نزاع وهنحتاج فيه للخبراء حتى لو رحنا للقضاء.
And actually, this is what happened, and I'm going to tell you what the expert or the one who did or reviewed this determined. But I just want to just get your impressions. Mr. Ahmed Al-Fawal.
شكرا. حضرتك قلت ان هو ديزاين بيلد كونتراكت صح؟
لا ديزاين بيد بيلد.
سوري؟
ديزاين بيد بيلد.
اوكي. طيب هو انا كنت فاهم ان هو ديزاين بيلد، فبالتالي ممكن يبقى لو كنت كده
it was resolved. If it is a design and build, it would be resolved at the beginning of the issue. It's the contractor liability, but of course here it's a design bid build.
تمام شكرا.
Okay, so in this essence, the court or the dispute resolution awarded an extension of time. Awarded an extension of time to the contractor. However, they rejected the associated cost because they said, yes, there was an error in the employer, and there was a very big explanation of this one. But you can just get to the green book to read it in total. But the final determination here was, yes, we will award an extension of time to the contractor, but there was no concurrency. However, we are not going to entitle the contractor for any liquidated damages, for any prolongation costs related to this issue, because the contractor has an apportionment of the error at the beginning. So agree or don't agree? Yes, I see some sense in this determination. However, this is a sort of apportionment or a way of apportionment between a case that has two contributions between the disputed parties. Here is in simple, the period of prolongation, which is the contractor, which is associated with the extension of time of the contractor, is not necessarily co-executive with an extension of time for delay to completion of the work beyond the completion date, because it's not always the contractor is not always suffering damages or overheads, not because of an extension of time. Maybe the contractor is getting relief from LD, which is an advantage. Maybe suffer no additional cost. Maybe he's not going to suffer any additional cost after the completion. Maybe the contractor accelerates whatever happening, or when he suffers a delay caused by the employer, he accelerates and recover. Maybe he accelerates by mistake. So it's not always when an extension happen, it's not always related or less not connected always with the contractor's right or overheads or additional overheads based on the extension of time, because sometimes the contractor is just getting a relief, sometimes the contractor has an extension of time and he suffers no damages, sometimes the contractor accelerates, either he succeeded to accelerate or failed to accelerate this one. This is just some notes related to whatever related to extension of time. Okay, moving forward to the methods that are suggested to calculate or highlight the apportionment. The apportionment again is related to projects that suffer something, and this something can be attributed to the two parties. So it's not always associated with extension of time, but what we are going to discuss here is, or what we are going to correlate here is related to extension of time. So once the liability has been separately identified, which is a mandatory, just go back to if you dealt with before, if you dealt with extension of time claims before, one of the major steps in extension of time is to separately identifying the liability. One of the major challenges in extension of time claims is to see or to know who is responsible for this delay and who is responsible for the other delay. So once the liability has been separately identified, which is also part of the apportionment, it should be well within the capacity of any competent quantum expert to analyze the cost contractor has actually incurred because of delay to progress, disruption, or prolongation of its overhead. This concept is stated clearly in the green and red references I mentioned, and I've been through this concept a lot in most of my cases as an expert witness or an analyst working with entity like contractors or employers in delay analysis. The major challenge and what makes the quantum expert's life easier is what I'm giving him as a delay analyst, that Mr. Quantum Expert, this is the amount of delay or disruption or overhead or prolongation attributed to the contractor, and this is the delay, whatever attributed to the employer. Forget about the disruption, or it's something issue, but something else. But this delay is attributed to the contractor, and this delay is attributed to the employer. And the reason why most of my esteemed colleagues who worked with me in expert witnessing cases or arbitrational cases felt comfortable in the essence of working with me, or during working with me, or feel comfortable in working with me. It's not a matter of pride. Again, it's a matter of fact and matter of testimonies. They normally say that Hossam, you are just answering the $1 million question, which is who is responsible of what? Who is responsible of what? What are the amount of delay attributed to this guy and this guy? And actually, it's not a compliment. It's the job of the delay analyst. One of the major jobs. If you are just saying that we are delayed by 100 days and you are not attributing, so it's less useful in the terms of quantification of damages. So, and then we will do the apportionment. There is I'm not going to just to confuse you now. There is a theory called the net effect approach that we will reach at the end of the session. This is implemented constantly here in the court of law in the US. We have here the trial court, the appeal court, and the Supreme Court. Normally, we don't go to the Supreme Court, but we have the trial and the appeal. Normally, they rely on net effect approach, which results in that sometime there is a concurrency, but there is prolongation cost. We will come to this in this theory of apportionment. So what we learned during our experience with delay analysis, that once the concurrency was compiled in the first place to identify how much prolongation cost attributed to this amount of delay, or how much time that we are going to base upon to calculate the prolongation cost. In this theory, there is a way of calculation that will lead to paying the contractor an amount even if there is a concurrency. And this is very recognized. This is very well recognized here in the US courts. So what we are going to explain in the coming slides are apportionment method that were originally apportionment, but we are using them in the delay analysis or the delay claims or the extension of time claims. There are I counted 30 methods of doing the apportionment, 8 of which was taken by Dr. Firas as a concurrency calculation method in his esteemed book, his very valuable book he published related to delay analysis. However, I selected the major one, and I'm going just to skim through these methods in the coming, let's say, 45 minutes or an hour, and then we will come back and have some questions maybe after the session. But all along the way, I will select some methods and try to correlate it with examples related to extension of time. So let's just go. The first 3 methods are straightforward. I'm now at the stage of identifying the apportionment method, because I see that an esteemed colleague has just joined. So I'm just highlighting where I'm at a certain point of the presentation where I'm explaining the several or the most popular methods of calculating the apportionment, 8 of which were taken by Dr. Firas in his book as concurrency, and I'm going to try to correlate these methods to extension of time claim with examples or with concepts all along the way. The first method is very funny, called the tortuous method or the tortuous approach. I'm going to explain here. I think we have here something like 8 or 9, 10 methods. Some of which are really famous and important, and some of which are answering some questions related to extension of time concurrency analysis. However, some of them are just very general, like the first 3. The first 3 are first the tortuous approach. Tortuous in terms of translation means التعذيب، طريقة التعذيب. The tortuous approach or الخسارة أو الأذى. Okay, so I'm just translating it for the sake of translation. The tortuous approach is just saying that the contractor will recover all its losses if the event in question caused or materially contributed to attributed to the employer. So for the tort claim, it's important to ascertain that the breach of the duty of care in the tort of negligence was the cause of loss, and that the loss can be considered to have been reasonably foreseeable and not too remote. The tortious, it is simply, I'm a contractor, I suffered a claim, an extension of time claim, and I will be recovered from all my losses. If a contract allows this, and all what we are explaining here are bounded by the contract, so if the contract is neglecting or negating any of what we are, what any of the concept that we are explaining, then the contract prevails. But anyways, the tortious approach here is something that allows the contractor to recover everything. In extension of time, it's more linked to the prospective analysis if the employer decided to compensate the contractor and consider the prospective analysis as a method to quantify the delay and the money. So he is torturing himself by paying the contractor everything, because the prospective analysis, the analysis that concerns about the future or event that has not happened yet. So all the time or all the money are estimates. So the duration of the fragment and the impact and everything are just estimates, can be revised later on. Some owners, especially in design build contracts and critical contracts, are not critical contract actually, short-term contract, but critical. It's a fast-track project that needs to be done immediately, or done in a very short period, or in a fast-track mode. The thing is, these guys, these employers, gave the time impact analysis, the prospective time impact analysis, the essence of calculating or estimating the amount of time and money associated with the extension of time, on a condition that the contractor will never come back to this event again, and he will be committed, or he will commit to the revised baseline based on the entitled or the granted extension of time. So if I'm a contractor and I'm trying to get everything based on whatever I'm suffering, whatever I suffered with due to event attributed to the owner, I'm just submitting a prospective analysis saying that this event will happen after 1 month and it will result in 1 month extension, and this amount of prolongation cost calculated like likewise the previous session. The owner will say, okay, I'm going to grant you 3 weeks and I'm going to pay this amount of money based on my calculation, but the revised baseline will be 3 weeks and you will be committed to this, and the amount you will be committed to this, I'm not going to exceed it for this event again. I'm not going to revisit again. So that if the event took 3 months, it's not my problem. You have committed to this one. So it's a bit two ways tortures. But again, it's just a very limited method. The second method is the burden of proof. If part of damages is shown to be due to contractor's own breach of contract, contractor must show how much of the damage is caused otherwise than but by its own breach, or else it can recover only nominal damages. It simply touches with the concurrency. So in the extension of time, whatever method we are using, normally, sorry, just a second. Okay, I had to plug the power. Normally, when we are using a kind of concurrency method or concurrency analysis, we are separating the paths, and the contractor is submitting an extension of time, and the contractor is not showing his concurrency, and the owner is saying that, Mr. Contractor, you have not shown the concurrency. And I was just discussing a claim yesterday with one of my colleagues, and he said that one of the major comments that came from the employer is that the contractor has not done the concurrency analysis. So if the contract is silent or has not mentioned this, some owners or some employers are using the burden of proof to put an obligation on the contractor to do the concurrency analysis. Why? Because in concept of burden of proof, the claimant, the one who's submitting the claim, those who asserts should prove. Okay, so the claimant is the one who has the burden of proof that he suffered the losses. Okay, so if it's not the burden of proof, there is no burden of proof on the owner to prove the disadvantage. It's the contractor to substantiate and prove his liability, his title, his entitlement, and substantiate whatever he's submitting, proving that he suffered these losses. Sometime when an owner submits a comment saying that Mr. Contractor, you need to come and do the concurrency analysis, the contractor replies back, if I can see that there is no concurrency, okay, and if you see, Mr. Owner, that there is a concurrency, please do the analysis. This is not right or wrong. This is not correct or not correct. I've just seen this. I was just discussing this the day before yesterday and yesterday with a friend again. The point here is both are right. And if the contract is silent, yes, both are right. Why both are right? If you are using the burden of proof approach and the contractor is submitting a claim, claiming that there was no concurrency, and the owner sees that the contractor has missed the concurrency analysis, yes, the contractor, based on the burden of proof approach, the contractor, if a part of the damage shown is due to contractor's own breach of contract, contractor must show how much of the damage is caused otherwise than by its own breach, or else it can recover only nominal damages. It simply, in simple words, it says if the owner negates or argues the entitlement of the contractor to the full extension of time and full prolongation cost for this extension of time, not the owner, the contractor should prove otherwise, because he's the one initiated the claim. Maybe this is aggressive a little bit, but if we go to the owner side and maybe he does not want to issue a concurrency. Otherwise, if the contractors keep insisted, and this is what I stated to Mr. Muhammad Salim yesterday, if you insisted that there is no concurrency and the contract gives the employer or the engineer the power of determination, he then can do his own concurrency analysis and determine a certain amount, not the full amount that you are asking for, or he can say that it's completely concurrent. There is a complete concurrency and you don't deserve any prolongation cost. So this is an approach, apportionment approach, that was driven to the extension of time claim. The third one is called the Devline approach. It's named after, I don't know what it was. I think it's someone or a case called Devline. If losses caused by one of the of two causes, both caused and cooperating at the both of approximate equal efficiency, the breach is sufficient to carry judgment for all the losses. And actually, Mr. Devline or Devline case gave us a very predicament and put us in a great bewilderment. Bewilderment يعني حيرة, تمام? Because of the Devline, the delay precedence concept erased. Delay precedent concept erased. if we try to understand the first paragraph, which is the only one I'm going to read, the loss caused by one of the two causes, both cause cooperative, and both approximately equal efficiency, the breach is sufficient to carry judgment for all the losses. The one who starts first, or the one who president, or the one who delayed first is the one suffering the loss, or the one suffering the loss. And actually, Mr. Devline here put us in a great predicament, مأزق, because he issued or initiated the concept of who delayed first. So here, the problem with adopting this approach is that in concurrency, there is not one approach breach, but two causing the same loss. This negates the concept, or complicates, actually, not negate. It complicates the concept of concurrency. So Mr. Devline says, in principle, and actually I've seen this a lot in meetings between owners and contractors, the contractor is submitting an extension of time, and the owner is saying, but Mr. Contractor, you were delayed first. First, you need to recover your delay, and then we talk about extension of time. This is not completely wrong. Yes, there is an approach that honors this. However, is this fair or not? I cannot judge, but there is an approach called Devline, sustaining the delayed precedence. However, the contract is silent, is not saying anything about this, even if not, even in the terms of ownership of the float, is not saying something, because the delay precedent is coming to a certain point where it supports the delay precedent. It's being supported by the float ownership concept. But anyways, this is another detailed part. But anyways, Mr. Devline here put us in this predicament, and it is his problem, or the case problem, to solve it. My understanding and my recommendation, not my recommendation, actually, I mentioned this recommendation in the previous session as part of the reference recommendation to those who are working with contracts. Please try to elaborate a language in the contract to solve these issues. So it's very simple to just give a concept or a precedence, or set a precedence concept to calculate the concurrency, to understand the concurrency, to deal with the concurrency related to this issue. Mr. Alim, تفضل.
Thank you.
Go ahead, please.
To be at point, is different approach you mentioned
Devline.
Accredited or certified by SCL?
Look, the references we are using, all the methods are recognized in the common law, and anyone from the contract background here can correct me if I'm wrong. In a common law, once we have a court case or court cases that supports this, the approach can be certified. So all the approaches mentioned in the green book or the red book are supported by numerous court cases, numerous, not one. So Mr. Devline, burden of proof, torches, and what are coming are supported by cases, and that's why I'm insisting that every single case is a case. You can just give a reference to another case or something like this, but to another case in terms of precedence or term of similar cases or similarity or something like this. However, all the methods here are supported by cases. And on other thing related to your question, Mr. Abdul Alim, is that the SCL or the RP are not listing to this level of details. The SCL and the RPs are just giving some highlights, even if it's detailed. They are detailed highlights. They are giving some method of implementation. But the reference books, when they mention a method, they support it by a lot of court cases. So there is you will find nothing in the SCL or the RP saying tortious approach or burden of proof approach or divine approach or whatever dominant case approach, the coming one, or the net effect approach, the last one. However, they are supporting this again with court cases. I hope I answer.
Yes, your answer is complete. Thank you. So the background is here is common law and cases by case. The next question. يعني هل كل طريقه من دولت مذكوره في الكيسز اللي حضرتك اللي بتبقى موجوده ديت
ولا لا هي they come with the case and they name the case after the approach after the case. يعني there is a case here that there's an approach coming here called city in approach. Okay, there is a case coming here, case number 10 or 11 or 9, something like this, called city in approach. City in is a case. Okay. So there is a case that the judge, not only one judge, the level 1 judge and the appeal judge and the judges that were involved in this one give some explanation, and so they took the case and make it a precedence to an approach called city in approach. Divine, I think it's the same. Divine is a case, and they use this. They named the approach after the case. It's vice versa. So it's not, we don't come with the approach and implemented the case. The case is triggering an approach.
I got you. Thank you.
Okay. Okay. So let's just, for the sake of time, I don't want to give you hard time and give you another 2.5 hours again, likewise the previous one. The other one is something called the dominant case approach. The dominant case approach, of course, again, if you are expecting to have a picture and a statement, you have to review your expectation. I like to write a lot so that you can refer to the slides in case you want to refresh your mind. The dominant case approach, I'm not going to read. I have a conclusion here, but the dominant case approach is under this approach, we are trying to separate the effect of the contractor and the owner in terms of something called the dominant case approach. And the thing, or the funny thing, is we took this in the extension of time. And for those who attended any session related to extension of time, not my sessions, but any session coming from any esteemed colleague explaining the extension of time, they should have heard about the term dominant cause or dominant delay. The dominant delay is coming from the dominant cause approach. The dominant cause approach, and also there is a method called the but-for in the SCL, the as-planned but-for, or the as-built but-for, or 3.8, 3.9 in the RP, the methods that are retrospective, modeled, subtractive, single insertion, or multiple scenarios insertion. These all the list of concept of the delay analysis concepts that I mentioned are coming from the dominant case approach. How is that? The dominant case approach is contradicting or quite the contrary of the divine approach. They are simply saying it's not about who started first. It's about the dominant. The dominant means the dominant in terms of common sense, or in our extension of time analysis, the dominant in terms of critical path or longest path. So if you are, just to understand it more, if you are doing it in Primavera P6 and you are adding events, you can add an event that will cause a path that is delayed by 100 days, and you keep adding events and it's still 100 days because the first one is dominant. The first event created a longest path that is absorbing all the other delays. In this dominant case approach, the bold line here stating that the cause for which employer is responsible is effective dominant cause of loss that has suffered. Which cause is dominant? And this is the name of the game. Which case is dominant is a question of fact. Is the question of fact. which is not only by the mere point of order, not the order of time, who comes first, who comes next, but to be decided applying common sense standard in terms of contractual. But in our delay analysis, we don't go for common sense. We go for something called the critical path analysis. And there is a story here. I put it in 4 blocks and a conclusion. The story says that if on Monday the work is suspended due to no arrival of drawings, okay, and we received this drawing on Friday. However, in Tuesday there was a labor strike or labor issue or something happened, and the labor did not work or did not show up and turn up on site, or still for a reason something happened Tuesday and the labor were not there. Can we say that there is an apportionment here? Can we say that there is an apportionment here according to this approach? No. The dominant case was the work, and even if the workers showed up and worked properly on Tuesday, the work will be still suspended. So the major approach in terms of contractual understanding is the first one, not the second one. He goes further and say, what if on Tuesday the building burned down? Can we say at this point that, guys, even if we receive the drawing, there was no building? Common sense says no, or this dominant cause approach says no, or suggests no, that because of the drawing delay, this is something that are dominating the delay, and this is what pushed this up to Tuesday, because no one would know that the building will burn down. This is something unforeseeable. If we move forward and just put another assumption, suppose then the fire does not burn the entire building. Can we resume the work? Still no. So the question that negates the previous one in terms of common sense is that, what if the building was not burned entirely, burned partially only? Can we still work? No. The conclusion of this part is simply there will always be a dominant cause. In this formula, the but-for test, the but-for, which came up with 3.8, the but-for test, which means that if you neglect or the subsequent event are discounted, subsequent is the اللاحق التالي, the subsequent event are discounted. If you remove the subsequent event, the work could proceed. If the subsetting factor is not occurred, then the subsetting factor is the cause of disruption cost, or the prolongation cost, or the delay cost, or the damages. This means, in simple word, if you have a cause that is dominant here in terms of common sense, or in Primavera P6 when you are doing a delay analysis, that is causing the highest or the longest path, this one is the one you use to measure whatever damages associated with time extension. That's why, and this was my argument in discussing those who were algebraically summing the total of the paths. In some cases, and some strange cases, and this is I'm not talking about cases that are hypothetical. I'm talking about materialized cases that I faced in prospective analysis or in impact as plan. Once they do the analysis, they come up with each event. Event 1 caused 10 days, event 2 caused 10 days, event 3 caused 3 days, blah, blah, blah. And they sum them. They don't go for the n+1 or the dominant cause principle. They just sum them. I mean the contractors. So my argument was, guys, we are talking about something called dominant delay. The dominant delay is the one used. That's why I insist when I have authority to go for always, when we use methods like prospective analysis or impact as planned, or I'm not going to say retrospective time impact analysis because it's controversial, but anyways, I insist on n+1. So if you do for each event and you do one model with all events, so n number of events, you create XCRs or prima verifier for each event, and then you create the bigger picture, or the n+1, which will determine the dominant cause or the dominant event. So here we have always a dominant cause, which is the subsetting factor. This subsetting factor is the one suspending the work. Whatever happened after this subsetting factor can be considered if it has an impact. So if whatever we presumed here, that the labor strike or the fire or something happened after Friday, which is the day when the drawings arrived, we can consider it. But once we are suspended because of something, we cannot consider the others as dominant. We have another dominant. Maybe the others has some contribution in the extension of time in terms of concurrency. However, there will always be a dominant effect. There is another example, and this is with this comes with an effect here caused by the project duration, and the employer gave a variation, excusable and reimbursable. So this extended the time, and adverse weather excusable but not responsible occurred here, and the contractor is claiming that the adverse weather can be considered also part of the problem or part of the claim as an extension. The point here is that yes, the dominant effect or the employer, in this case, guys, in this case, the employer issued a variation that extended the project all the way here. And then during the extension, because of this extension, an adverse weather happened after the time for completion. Adverse weather, the employer is refusing to compensate the contractor for the adverse weather. So the contractor argument is that the effect of the adverse weather would never happen unless you gave me this variation, because the adverse weather occurred after the time of completion, which has been extended because of the variation. According to the dominant case effect approach, yes, this is a subsequent effect coming from two events, not one event. So if the adverse weather has an additional impact, the contractor, according to the reference, according to the case coming or supporting this, can be included as an excusable and reversible effect. This is just a continuation of the dominant cause effect. This is another example. Just this is highlighting the first one, or just trying to sustain the concept we mentioned. There is a famous number 5 is just read it. It's just doing the same or singing the same song. I don't want. I just for the sake of time management, I'm not going to read it in details, but it's just sustaining the same concept of apportionment related to dominant cause approach. There is something I put it here because it's strange actually, and it's not relating on anything. It is relating to the judgment or the experience or the evaluation of those who are doing the arbitration or dispute resolution. It's called the jury verdict approach. Verdict means al-hukm. Verdict means al-hukm. And this is concerning global claim. I have a slide here where global claim is being defined. So I'm going just to skip and come back. Global claim is where a contractor makes a claim for a single amount of money by reference to multiple underlying causes or events. They typically arise in the context of delays where there are multiple concurrent cases of delay. Okay, sometimes we call it Hail Mary claim. It's just putting a claim saying that I have all these and I want this money, I want this time. It's not a detailed claim, but it's a big, very big claim at the end of the project or the late age of project, submitting a multiple ways of multiple claim delays, and it's very difficult to substantiate or analyze. The verdict approach, normally in the case that they went for the verdict approach, the verdict الحكم او التقييم القضائي يعني, the interference to be drawn from the term that were faced by global claim. A court just makes a subjective impressionistic assessment or guess of damages in the same way that the jury might. It's famous in North America, and they are relying that the judges and the jury is not the judge, the jury is المحلفين, those who are sitting aside and doing something. The jury in the arbitrations is a bit different, not like the jury in the criminal cases that you are watching in movies. But anyways, the jury verdict is very famous here, that those are experts and they will just read the case and do some kind of impressionistic coming from impression, انطباعي, impressionistic assessment or guess for the damages and the apportionment of these damages. There is no basis of this except the expert experience and the qualification and the judgment of those who are doing the arbitration. So it's not that they are saying that it's coming from the one who invented this is the federal law. It's emanating from the U.S. federal law, federal courts, and they are not using it extensively. However, there were some examples and the reference about cases, common cases or civil cases that were resolved by the jury verdict approach. Coming back to global claim, there are some calculation that being done, and you will see 3 slides that are mostly the same, but the way of calculation is what separates them. Okay, in global claim there is an approach called modified global claim approach. So I have cost of work tendered, and this is the cost of work tendered, so this is the price of the contract. I have some prolongation and contractor and unbidding cost. This is part of the contractor mistakes. Prolongation of 3 is the contractor 3 and 3, B and C. These periods are contractor delays, and based on this delay there is prolongation due to the employer. And unbidding cost, this increased the cost a little bit. And there are some prolongation and contractor delays cost based on period 4, which is the employer delay. And this is the total increase of cost. Once we reach a point where the contractor is submitting a global claim, estimators can just say that based on our actual record, this is the new amount of cost associated or added to the project or the contract price. And we are not going to go into details, not us, they are not going to go into details, but the contractor claims or the contractor delays or the contractor attributed delays are, let's say, 30% of this cost, and the employer is 70%. So we are putting a global claim that we are claiming for, we have $1 million added, and we are claiming for 700,000. Of course, this is exclusive for global claims. We don't do estimation. We do estimation for totals. How much money the project cost us, how much money this is going above the work tendered, and what is the percentage associated with delays attributed to contractors, what are the amount of money associated with the employer in terms of percentage, and we go for evaluating this one. This one is associated with global claims, and normally the employer do not accept this. The employers do not accept this unless they are in a situation that they have to finish the project. In some projects here in the US, of course, you know that when you are dealing with a public agency in a well-established country, I'm not mentioning the US. US is a country with the same defects that many of the third world countries have. So, but anyways, if there is a strict regime and a well-established jurisdiction system and legislation system in the country, public agencies like the Ministry of the Department of Transportation or Department of whatever are committed to the public and committed to the governor and committed to the communities to do the project in certain time with certain level of disturbance to their daily life. So if, and this has happened here in one of the projects, when a contractor is using this or abusing this and submitting a global claim to the contractor to finish the project, claiming that he suffered additional cost, and there is a language somewhere that gives a kind of round figure or ballpark figure apportionment to those two, the employer sometime under the pressure of public, under the pressure of community, under the pressure of the yearly target he is committed to the public, sometimes they accept such kind of claims. And I've seen this with a $37 million claim and a $5 million claim here in two different projects. And I've seen this also in Abu Dhabi in a project associated with Al Maria Island, where the contractor submitted at the end of the project, at the last stage of the project, he submitted a global claim with estimated prolongation cost based on nothing, based on extension of time that he accelerated or an extension of time he has granted, and he submitted this claim, and he claimed for 65%. I don't remember the number, I'm sorry, but he claimed for a huge percentage, more than 50% of the additional cost on the project, although the project was lump sum, and the employer negotiated this, decreased it a little bit, and he paid the contractor in order to finish the project and fulfill his commitment to the public. So it's exclusive for global claim. That's why they went for the next approach, which is the modified total cost approach. It's still doing the global modified cost total cost approach example. We have given a quotation here. It's a company here. Just the modified global claim approach. The second one is the modified total cost approach. In this, the modified global claim approach turned into total cost approach, where you will see it's mostly the same. The only difference here that we have additional cost here, but we do an attribution of delay cost or impacted cost, and we calculate the 4 and 6, which are delay by the employer, by 6 and 4 only. What is caused by 6 and 4 only? 6 prolongation of 4, and 4 the employer, the prolongation of 4. And you notice here that the prolongation is coming in two portions. The prolongation of 4, which is the losses, the direct losses coming from the employer delay, and the normal prolongation cost. So if the employer delay is caused idle resource, yes, it will be impacted. If it caused something like inflation or impacted by inflation, okay, no problem. It will be added. And in addition to this, the prolongation due to this extension that I explained in the Excel sheet last session. So the only difference here is that we separate the causes and we do proper estimation, not as whole percentage. We do proper estimation for whatever comes from number 4. We don't pay the underlying cost, we don't pay the contractor attributed delays cost, and we don't pay the prolongation of the contractor. We pay only the prolongation coming from the employer and from or the losses associated with this delay coming from. So it's mostly the same. However, we do the estimation for the part associated with the contractors only. Okay. The same, it's just an example here. We move to A/B estimate, independent estimate. The only difference here, again, we assuming that A and B plus B is the composite of item 4 and 6, where A plus B said that C actual equal to contractors total recoverable cost. Total contractor recoverable cost is estimate of original element of the work. So it's A, estimate the total estimate original of the work, and B is whatever the contractor suffered. The only difference here that we are not doing the estimate inside the project. We hire an independent estimator, and it's very famous here in the North American customer. We call the ICE independent cost estimator. The ICE is an agency that gives you an independent estimate of damages. So in the project, we say that these damages has come to the contractor, and these are the records. Please do an estimation based on the new prices, the prolongation, the labor rates, the items that you have seen in the previous session related to the contractor losses. We do it, but we are not doing it on the site, but we are doing it using an independent estimator. As I mentioned you and Mr. We have, I believe I saw Mr. Ahmed here. Mr. Ahmed he was the one who has drawn my attention to CTN approach before, and he had delivered a very valuable presentation related to concurrency based on the CTN versus Shepard approach. So thank you very much, Mr. Ahmed, for drawing my attention to this long time ago. I think 2 years has passed now for this. And I recommend you to go to teachcamp website or YouTube channel. Engineer Ahmed's lecture is very valuable in terms of concurrency, taking into consideration this case and other cases. It's recorded, and I think it's in the YouTube channel. And if I have here some of one of the great organizers we are having, please just, if you would post Engineers Ahmed, if after his permission, of course, if you post Engineers Ahmed lecture in the group so that everyone can benefit from the informative case he presented in his presentation. CTN versus Shepard, this was a case that inspired those who wrote the book with a new approach called CTN approach. CTN approach is a very funny case to me. I'm just giving you what it's deeper than this, but in the CTN approach, they did a very funny thing. The funny thing here they did is that the judges said, okay, the contractor is claiming 11 events at the employer's liability for which claimed prolongation cost, but was unable to distinguish which events caused by which losses. They could not separate the dominant or attribute the dominant to which one, or attribute the delay to either one. So we have 11 approaches for which the claim prolongation cost, but was unable to distinguish which events caused which losses. The judge having apportionment entitlement to extension of time for 11 weeks delay to complete the work according to the number of claims. So the judge said, oh, every claims made by the contractor, list 2 claims by the employer. So the employer has two claims that the contractor was delayed equal 9 weeks extension of time to the contractor. And this is what happened actually. So the judges, not in details, but the judges looked at the table and look at what happened, and this is the trial court. The appeal court went for the net effect approach, which is the last one. And I recommend you just to bear with me. I know you are listening for nearly now a couple of hours, but I recommend you for if you went that far, to 1 hour 52 minutes, just bear with me for another 15 minutes, because the net approach is the last one. I put it the last one just to keep you locked in the lecture. But anyways, the first level of trial here, the judge did a very strange apportionment. He did an apportionment that the contractor is liable for 2 events, and the employer is liable for 11 events. They were not able to distinguish, so they said, okay, 9 weeks extension of time for and the total request was something like 11 weeks or 12 weeks. He said, okay, using the apportionment of numbers, we will give the contractor 9 weeks and the prolongation of the 9 weeks. In the book, in the reference book, they stated this bold line: this is an unattractive approach to apportionment of loss for several reasons, among which the completion work delayed because of matter of both employers and contractors. It's common sense that there is a concurrency here that needs to be looked at. The contractor could not do it. There was no basis of which the court could do it. If the contractor could not do the apportionment, or the employer could not do the apportionment, that this will consequently mention, or that consequently concludes that if the parties could not distinguish, the court will not be able to distinguish. But in the appeal court, they went for further, and they negated or they challenged the concept of concurrency itself by the last approach, which is the net effect approach. Okay, so once there is another case, which Hiller versus Klangsmith. Anyways, this is not the naming of the court is not the point. The point is that during this case, in this case, the court found the contractor had delayed its subcontractor work in a completion of parking garage, but that the subcontractor was contributed to delays on the parking garage and caused delays to another project aspect. The first instance, the court held the delays were concurrent and neither could recover losses, which is the concept of concurrency. Guys, this is the concept of concurrency. If you have a concurrent delay that are moving together from the cause and impacting the project when an effect that are concurrent, so neither party will be compensated, whether this is contractor subcontractor or employer contractor. We are using the major concept of concurrency, which states that if we have concurrent delay, we don't compensate the contractor. But the appeal, they said a lot. The judge gave a very big statement. The meat of this statement is a rule precluding a party from recovering damages for delay once the party itself delays would leave the parties to a contact unnecessarily vulnerable to delay by others. So he went to a very interesting way of assessing the concurrent delay. He said, ignoring the subsequent court in the decision, he got the doctrine of the concurrent delay. Got the doctrine, it's a medical term, means I just don't want to give you the real meaning because it stinks. But got the doctrine بينقض المبدأ او بينقض gut يعني يهضم، بس gut the doctrine means ينقض المبدا. هو نقض هنا نقض مبدا الكونكرنسي which means he got the doctrine of the concurrent delay. هو نقض مبدا الكونكرنسي بطريقه غريبه قوي، ان هو sorry he got the doctrine of the concurrency in a very strange way. He didn't calculate the prolongation entitlement by a day-to-day, because day-to-day it will conclude a zero delay to the claimant. He calculated dollar for dollar. Dollar for dollar means what? In an example, if dollar for dollar, the net effect approach, and this is very famous in the US, by the way, and I've seen it in an arbitrational case in Qatar Metro, Doha Metro, in the state of Qatar. If party E delayed by 30 days, and there is a party C, who is the contractor, has a concurrent delay of 30 days. So it's 30 by 30. So it's the cause of the delay are concurrent, and both are causing 30 days of delay. So again, the claimant is claiming 30 days of extension of time, and the analysis showed that there was a concurrent delay of 30 days. So in the doctrine of concurrent, before getting it, in the doctrine of concurrent, the claimant will be granted an extension of time, but he will have zero prolongation. But for Mr. I mentioned the reference because this is not the green book reference. I searched for another reference for this method, and I'm mentioning here the case, the Hiller versus Klingsman. So in this case, or the net effect approach, the judge or the arbitrator who went to or determine or give the determination here used cost estimators, and he came up that E will suffer $500 per day. E will suffer $500 total dollars per day for the 30 days. So E will suffer $15,000. However, C, who is the claimant, will suffer $1,000 per day. So he will suffer $30,000 of damages. So even if they are concurrent in a day-to-day approach, they are not equal in terms of losses. So he said, although there is a concurrency, C is entitled to $15,000 of loss. $15,000 of loss. So although there is a concurrency, but in terms of comparing the apportionment, a party lost 15, however, the other party lost 30. So it's not fair, according to the judge here, it's not fair to apportion zero for the 30,000 losses or the $30,000 damages due to the delay, given that part of the delay is attributed to E and the same part is attributed to C. Is this correct or wrong? I think I cannot judge. I'm not a judge, but a very famous case, a very respectable reference mentioned that there is something called net effect that concludes that even if there is a concurrency, you have to go for the actual net cost and see who suffered damages more and give the difference. The disaster happens here when some people are using this for time. So I cannot judge. I'm not judging here, But I've seen cases where the employer comes to the contractor and say, Mr. Contractor, you are delayed. I'm delayed by 3 months, 90 days, and you are delayed by 60 days. And this is a concurrent delay. So I'm going to give you 30 days. No one in Mother Earth have given a rational, reasonable justification of this one. I can justify and defend and buy off for the net related to money. However, implementing this in time is, with all due respect, nonsense. And the funny thing is that they call it, we are using the net approach, or we are using the net calculation. So calculate the net. So it's 90 minus 60, the concurrent, so you will get 30. 30 is an unjustified number, according to my opinion. And of course, when I say my opinion, I'm saying that this is my opinion, and it can be, just getting back to the first slide I showed you when I started this session, may Allah protect us from those who are asserters. This is my opinion for now, but I've never heard a justification, or my mind failed to justify or rationalize applying the net effect approach in time, in the terms of time. But in terms of dollars, yes, there were cases, and actually, in my opinion, it makes sense. It makes sense because the concept of damage is to not to profit from damages, but to recover damages. So the concept of damages, or the concept of covering the damages, is far reasonable and rational than the concept of dealing with this or doing this for the time essence. Okay, extension of time tricky examples. Of course, we have been talking for nearly 2 hours now. If I started my extension of time tricky example, we will just, and I think it's 9 p.m. in Cairo now, and it's maybe later than this in United Arab Emirates or Saudi or Qatar or wherever you are located in. So what I'm trying to say is, what I'm trying to clarify is, I'm not going to trick you and say that I'm not going to give you the examples. I have already prepared 5 examples, 5 extensive examples for extension of time tricky examples, one of which is 3.3, MIP 3.3, two of which are 3.7, one of which is 3.4, one of which is a prospective analysis. And I'm going to supply you, again, for those who missed the first part of the session, I'm going to supply these examples as short videos. The first one is with the organizers. So I think with the video of this one, or maybe earlier, they will provide this first example. The first 2 videos are just, I've said now, MIP 3.7, 3.3, this kind of tricky stuff or strange stuff. However, I'm presuming that we are not all on the same ground of understanding the methods of delay analysis and extension of time analysis. So yesterday I created a video of 30 minutes total, 2 videos, total 30 minutes, explaining or putting or setting a common ground for the methods of delay analysis. The video was shared with the organizers, and they will share it with you. And during the coming weeks, I will be giving you example by example. The group is up and running. So if you have any questions related to today's session or the previous session, and I believe the video of the previous session was posted also in the group. So if you have any questions, please feel free to contact me via the group or via my WhatsApp. But just be mindful that I'm 9 hours up to 10 hours behind you or before you. So I might give the answers a bit late or a bit in a little bit strange timing. I hope I've been. I'm sorry if I will not be able to take questions directly today, but not today now. But I'm open to questions in the group or via email or via Facebook or via my personal WhatsApp. I would like to thank you very much for your patience and your attendance, and I hope I've given something that is valuable, and I hope I've been a useful resource for you for the 5 hours we spent together last the Saturday before yesterday, before the previous one, and this Saturday. Again, thank you very much, and have a great evening. Good night for those who are going to sleep. I will be starting my day, so thank you very much again, and I'm open again for any previous questions. Thank you very much. I'm looking forward to seeing you very soon. Bye-bye.